At Home Around the World, the new edition of Richard Wilmot Smith on construction law, a modern, authoritative, comprehensive textbook for national and international construction dispute resolution practitioners. I'm Jonathan Bellamy from 39 Essex Chambers, and I'm here to introduce this episode of one of the 39 Essex Chambers Commercial and Construction podcast series called At Home Around the World, and to promote the recent publication in June 2021 of the fourth edition of Wilmot Smith and now Paul Darling on construction law, edited, that is, by both of them. This is an international episode, and it comes from a key jurisdiction for 39 Essex Chambers, and that's Singapore. We practice from offices in London and in Singapore. As I've said, my name's Jonathan Bellamy. I practice as counsel in litigation and arbitration and as a chartered arbitrator in national and international construction, infrastructure and energy disputes. I work from chambers in London and Singapore. I'm privileged today to be joined by Paul Sandosham, a friend and colleague who has worked in dispute resolution in the construction sector for over 25 years. He's a partner of Clifford Chance Asia and is the lead on infrastructure, energy and resources disputes for the whole of Southeast Asia. Paul and I have had the privilege of working together as co-counsel in a case in Singapore, and not so long ago, with success that proceeded through to a final award. Paul, welcome, and we envy your good weather and presence. So, to turn to the book itself, Paul, we like to think that this is an Oxford University Press, modern, user-friendly, and importantly, accessible alternative to the Sweet and Maxwell competition of Hudson and Keating. We'd like to think the price is competitive and it's marketed at significantly less than its competitors. Paul, I was going to ask you, what is it that you and your colleagues look for in a comprehensive construction law textbook?
Well, first of all, good morning, Jonathan, and it's afternoon here. I wouldn't say the weather is much better than yours, but probably warmer. And thank you for the invitation to join you at this session. And thank you for a complimentary copy of the book. Well, firstly, I'd like to commend the authors and contributors of this book, because having been an editor, author, and contributor to several books before myself, I appreciate the time and effort that goes into putting together something like this. And it's all very exciting when you meet the publisher and agree to produce the book. However, that all changes when the hard work of writing and editing takes place over the course of a year or so. However, there's a sense of achievement when you see the finished product, and there's also a sense of pride when your book gets quoted to you when you're sitting as arbitrator. And of course, you hope that nothing in your book is ever used against you in your own legal submissions. So coming back to your question, what do we look for? I think firstly, it needs to be user-friendly. As counsel to clients, we are usually looking for an answer to a specific legal question, and if the book can give us that answer in a clear and concise manner, it achieves its main purpose. I think secondly, it needs to strike a balance. And what do I mean by that? It cannot be too light in its analysis of legal principles, but at the same time, as practitioners, you don't really need an extended exposition on the law and how that principle of law has evolved over the centuries. That's not really important for us. I think thirdly, something often overlooked, it needs to be accurate. And I say that because I've come across situations before where the text in the book cites a proposition of law with reference to a case in the footnotes. But when you read the case does not actually stand for that proposition, and you can get caught out. So I think to summarize, those were the three main things, as a construction practitioner, I would look for in a good book.
Well, that's really helpful and really interesting, Paul. And I do know that you're an author yourself, and that's one of the great reasons why we're able to get you in. It is a lot of work, and I'm not claiming anything more than Chapter 7, which I was ably assisted by Johan Ho. The editors rewrote and recast, and with the help of the contributors, a lot of the chapters in this book. And I'm really pleased that the aims that we're trying to achieve match the sort of requirements which leading practitioners have, both here and abroad. One of our aims, certainly in Chapter 7, was to be modern and to be clear, and not to off-put readers by very dense paragraphs and lots of footnotes and, if you like, redundant legal history. We rewrote a lot of these chapters and tried to give a sort of stand-back view. I'm really interested in the point you make about the need for intellectual weight. That's obvious. This is an OUP publication. They demand that. How does one strike the balance for that? And I ask you also as a published author.
Yeah, I mean, I think to sum it up, as I mentioned earlier, I like something, and I think that applies to most of my colleagues, is something which is user-friendly and accessible. And in terms of the structure and layout of the book, I find it particularly helpful in terms of the way the chapters are organized. And it's a small thing, but the use of paragraph numbers in the textbook is something I find particularly helpful. And so on the whole, I like the way the book has been structured.
Yeah, we did work on that, and it's interesting you say that. Rather like a skeleton argument, isn't it? Clear English, paragraphs that deal with perhaps one topic, explore it a little bit more, reliable footnotes, not too many different points in the same paragraph. I'm really pleased that that's something that's attracted you. And I hear that your colleagues have been grabbing the book and taking it from you.
Indeed, the moment it arrived and I opened it from my envelope, it was taken away from me. And it's quite funny, when I got the book back, it's got full of tabs and labels on it. So it shows that someone's been using it.
Well, I'm delighted to hear that. Yes, good. We've talked about the style. I'd just like to move on briefly to talk about the substance. And again, you've indicated the sort of things you look for here. One of the approaches that we endeavoured to take here, and the editors endeavoured to take, was a comprehensive approach, a cradle-to-grave approach, if you like, starting in the 21 chapters arranged over parts that included the contract, liability, performance, breach, termination, damages, claims, and all the way through to the resolution of disputes. We wanted to strike a balance between clarity and basic principles, but also up-to-date law. How does that work for you? Do we achieve that, and is it of use?
I mean, definitely. I think I find the book very comprehensive. I mean, it covers every conceivable topic that is applicable to a construction contract, and to borrow your term, it does have a cradle-to-grave coverage of a typical construction project. I mentioned earlier, like the systematic approach of topics, and what I find particularly useful about this book is that it's one of the few textbooks that analyzes complex issues of law in the context of construction law and construction contracts. I mean, just as an example, the chapter on unjust enrichment, an area of law which many find difficult to comprehend. And in the past, you would have to turn to a standard text on restitution or unjust enrichment for generic answers to your questions. But what you have in this book is the answer in the specific context of a construction project, and I think that's invaluable. And while the book does deal in detail with legislation in England, it's not entirely Anglo-centric, because I note that there are comparisons with the laws of non-English jurisdictions, again, helpful for international practitioners. Some of the chapters I found particularly useful in my own practice were, for instance, Chapter 9 on performance bonds. As you know, the English and Singapore courts have a slightly different approach. So it's nice to see a comparison between the English law and Singapore approach on restraining a demand on a performance bond. Chapter 7, something you're quite proud of, which you touched on. I'm not saying it just because you worked on it, but exclusion, limitation, liability clauses. Again, congratulations for authoring this chapter. Again, it's very comprehensive, and I like the systematic way it deals with the exclusion clauses, the limitation of liability clause, and the indemnity clauses. But what's unique is that chapter just doesn't tell you the law and leave it to you to figure out how it applies to your fact scenario. And for example, there's a useful section at para 7.55 where the authors, yourself included, have analyzed the application of the reasonable test to each of the categories of exclusion and limitation of liability clauses discussed in chapter. And that's fantastic. I mean, it saves us the work of trying to apply the law to the facts when you're helping us do that in the text. And I find that really, really useful. And that's a real value add to practitioners. I mean, the last chapter I would talk about, again, which is, again, very unique to be found in a construction textbook, and that's chapter 20 on international construction arbitration. It's good because it gives a good overview of the arbitration process, but again, in the context of construction disputes and arbitrations. So I think that's one big selling point about the book. It deals with areas of law and procedure, but through the eyes of a construction practitioner and in the context of construction disputes and projects.
Yeah, that's thanks for that. That's really interesting. I mean, Unjust Enrichment was a great chapter. I know, written by Frederick Wilmot Smith, a real legal scholar, and of course happens to be the son of one of the editors. But he's drawn together this. So, as you say, to look at an unjust enrichment, which really is a complicated topic, and to try and extrapolate principles from, if you like, cases on leases or other types of relationship, often quite historic, is really quite difficult. And he's drawn it together in a really, really good manner. And I'm pleased that's of use. Also, the chapter on adjudication, which obviously doesn't interest you so much in Singapore, is being rewritten. I really like the chapter on international construction arbitration. I'm delighted that you found it useful because of your prominence in South Asia, both as counsel and as an arbitrator. Do you think it will be of use, that chapter, for practitioners? Do you think they will look at that and say,
yes,
how can we use this?
I'm pretty sure. I think all the textbooks that deal with or teach procedure and practice of international arbitration do it generically, but not with this construction focus. And I think this will be a useful reference point. And if you look at the statistics from most of the arbitral institutions, you'll find that construction arbitrations are pretty much the top three sorts of arbitrations that they're dealing with. So I'm pretty sure that this will be on the bookshelf of every construction practitioner as well as every international arbitration practitioner.
Yeah, that's absolutely right. I mean, particularly in Asia, construction arbitrations, infrastructure, etc., what the areas that you practice in are the statistics show the importance of it. And I think it will be of use to see this put in a construction context. Paul, thank you so much for your time. It's been a delight to see you again. It's been a long time since I've been in Singapore, and perhaps a long time since you've travelled. You must be looking forward to doing that as well.
It's probably been about more than a year and a half since I was on an aeroplane, and had plans for summer in London, but that's been disrupted by the situation. But hopefully soon, and definitely pay you a visit.
Yeah. Oh, yeah. Well, we look forward to welcoming you again, and we look forward to trespassing on your hospitality in Singapore. The very best wishes to you and all your colleagues and staff at CC. It really is a pleasure to have you here and to see you. And I really genuinely look forward to seeing you, in the very near future.
Right. Bye-bye.
And thanks again.